Hi guys, this is Erica from Gokche Capital. Now before I begin, be sure to click subscribe and turn on the notification bell. Consider this. You wish to sell your land in a homeowners association. You find an interested buyer and the title company begins the closing process. Yet shortly after, the sale falls through. You don't think too much about it, but then you get a bill from the HOA for $250. Is this legal? We'll find out at the end of this video. But first, if you ever buy or sell land in an HOA or condo, you may encounter HOA estoppels. And in today's video, we have the top things you should know. Number 1. What is an HOA estoppel letter? An estoppel letter is a legally binding document that certifies the accuracy of certain facts as of a specified date. Number 2. What does an HOA estoppel letter include? It varies from location to location, but generally the letter will show the HOA's name and contact information, the property owner's name and contact information, the address or legal description of the property, an itemized list of fees owed to the association, the date for which the balance will remain unchanged, detailed payment instructions, and an authorized signature from an HOA board member. Number 3. What does an HOA estoppel letter do? An HOA estoppel letter helps to protect various parties in the transaction. The letter allows the buyer to understand all financial obligations associated with the HOA and whether the seller has any outstanding payments owed. The seller can fully disclose any problems or dues owed, as may be required by state law. And the HOA is protected in the event of a lawsuit. Number 4. Why are HOA estoppel letters necessary? An estoppel letter is part of your due diligence as a land or property buyer, since it shows if the seller owes any outstanding balances. Number 5. How do HOA estoppel letters affect title insurance? If a property is in an HOA, the title company must first make sure there are no outstanding balances before they will issue title insurance. Thus, the HOA estoppel letter lets the title company know what is owed and ensures that payments are satisfied before closing. And finally, number 6. Who pays for the HOA estoppel letter? It varies from state to state and often depends on negotiations between buyer and seller, but often the seller pays the fee. Which brings us back to our opening question. What happens if the sale falls through? Can the HOA still charge a fee for the estoppel letter? In 2016, PropLogic, a title and lien search provider, filed a suit against a Florida condominium association over precisely this question. A few months prior to the suit, the company had ordered an estoppel letter from the condominium on behalf of a client. Shortly thereafter, the client notified PropLogic that the deal was canceled and sent along a cancellation of contract. PropLogic forwarded this contract to the HOA with a request for a refund, as the cancellation was within 30 days of the original closing date. They didn't receive an answer. They sent another request. Still no answer. Thus, they decided to bring legal action against the association, all for $250. Why? Well, under Florida Statute 720.30851, an HOA is required to refund an estoppel letter fee if they receive a request no later than 30 days after the closing date from a payer who is not the parcel owner. And the judge did indeed require that the association pay back the original estoppel fee plus court and attorney's fees. So the $250 the association tried to save ended up costing them $7,000. This was good news for PropLogic, but this case hasn't really answered our question. If you are an astute listener, you probably noticed that the property owner was specifically excluded from the Florida statute requiring fee reimbursement. So what if you are selling a property in a Florida HOA and the deal falls through? Can the HOA send you a bill for the estoppel letter fee? It turns out the answer is yes. That same Florida statute allows HOAs to collect HOA estoppel fees from the property owner, even if the closing falls through. Thus, if you own property in an HOA, check with a lawyer to see what your financial obligations may be. You don't want to be surprised by a sudden bill later. But what do you think? Do you have any stories about HOA estoppel fees? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down listings at gokcecapital.com/listings. Finally, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.